Domain 2, as we get ready for the RHIA exam, will cover information protection, access, disclosure, archival, privacy, and security. In a nutshell, we are going to look at reviewing HIPAA, both the privacy rule and the security rule. Many forget about the security rule, but that's very important in what we do. HIPAA training is part of a registered health information manager's job, and this is actually required by the law, if you remember. Your training must be covering the details of both HIPAA's privacy rule and security rule, but as it is appropriate to whom you are training. This is not an instance where you can gather employees, staff members from every department and do one generic HIPAA training. This must be done directed to what each individual staff member needs to know. First of all, this is efficient. Second of all, it is part of the law. But third, most importantly, you've all sat through lectures and trainings and webinars that in your head you're going, what do I need to know this? That's not part of my job. I will never use that. So we want to make sure that when we create training, it is appropriate for your audience. And also remember that training on HIPAA must be ongoing, at least once a year. This is also required in the law. Your core training, of course, you must make certain that all of your staff members understand what PHI is, Protected Health Information. A lot of times we get to know something so deeply and it's so ingrained in our minds that we forget that there was a time when we did not know what it meant. So this is very important that you ensure that all of your staff members are aware and alert of what PHI is. The core content for your training and the best source for this part, which is the HIPAA privacy rule, I suggest you find a copy of the HIPAA privacy rule summary. How difficult is that? Google it. It'll come right up. Make sure you get the one from the Department of Health and Human Services, the Office of Civil Rights. Do not take a third-party version of this. You cannot be sure that it's accurate. And the summary is only, I want to say, 9 pages long, and it really makes the whole entire privacy rule down into a nutshell, describing permitted and required uses and disclosures of PHI. You need to know and understand what each of these are. The fifth one is treatment, payment, and healthcare operations. Now, the one thing that I want you to understand and make sure it's ingrained in this particular case, the word operations has to do with operating the facility. It is not operations as in surgery. And by the way, you need to know the difference between a surgery and an operation. But we'll get to that later on. Okay, so read through all of this very carefully. And you can see how complex and involved TPO is, treatment, payment, and healthcare operations. Public interest and benefit activities. This is also something that many people do not understand. There are multiple issues with this, but this does give, under the heading of best judgment, reporting to the federal or state or local authorities. So this is not an absolute, you may not, without the patient's approval. And you will notice that the first bullet on this slide is required by law. And this specifically connects to the third bullet, victims of abuse, neglect, and domestic violence. HIPAA, the federal law, says you can, in your best judgment, disclose. Most of the states within the United States have a state law that requires, mandates reporting of suspected abuse, neglect, or domestic violence of children, women, and the elderly. And of course, we also know that there are certain diagnoses like contagious diseases that are on the mandatory report law. You are not violating HIPAA's federal law by complying with the state law. Just as an aside, and this is again part of the HIPAA privacy rule, which says if HIPAA says you may or may not, based on your best judgment, disclose, and a state law or even a local law says you must disclose, then you are to comply with the more stringent demand. So a mandatory report is more stringent than you may or may not based on your best judgment. So that gives you the hierarchy. Federal usually overrides state unless the language is more stringent. There are, of course, many reasons under this public interest and benefit activities, such as research, workers' compensation, and, of course, organ donation. So this information is important for you to know that this is all part of the you may or may not based on your best judgment. Okay, here are two terms that when I was studying for the RHIA, I looked at spoliation in one of the test questions and I was like, that's got to be a typo. It is not a typo. It's actually its own word, spoliation, and it specifically means the destruction of evidence. Okay? So I wanted to highlight this because I wanted you to make sure that if it comes up in one of your questions on the test, you won't be confused and you won't think it's a typo. Okay? Also, of course, encryption, which is used for technology transmitted information. Another concern that, or confusion that many students have is the difference between privacy and confidentiality. The right of an individual to keep their information to themselves or only to people who they say can know the secret is the right of privacy. This is like when you say to your best friend, I'm telling you, but don't tell anybody. And you really mean it. Confidentiality is on the part of the receiver of this private information. Confidentiality falls on the part of your best friend that when she pinky swears not to reveal your secret, this is protected. That is her obligation to confidentiality. So that's the responsibility for making sure that when something that is private is given to you, you will not let anybody use or disclose or release this information without the permission of the individual whose privacy this belongs. Security is the act of, well, you kind of know this, right? This is the act of locking your front door or locking your car and making sure that you have a password on your phone so that the information that is within or the property, but in our case, we're talking about information. So the information that is within is protected. You can't write your best friend's secret down on a piece of paper and leave it sitting on your desk face up so anybody walking by can see it. That is not keeping the information secure. So this is part of our obligation, and it is part of our responsibility of confidentiality to make sure that we are locking those doors and not the physical door. But you knew that, right? All right. Now let's talk about HIPAA's security rule. Usually, many people give a lot of time and effort into understanding HIPAA's privacy rule, but forget about the security rule. And the security, as I just said, this is the federal law that tells us what kind of locks we need to have on the doors and how many locks and things like this. So, this requires both physical as well as technical, as well as administrative locks on the door. Risk analysis is the process of going through and testing the system, investigating the system, and making sure that the vulnerabilities, which is an unlocked door, okay, or a door without a lock, or a broken lock on a window, those are the vulnerabilities that we know if you're thinking about the security of your home. Well, we have to do the same thing for the security of the information that we house in our computers. And so, therefore, a risk analysis must be done first to identify any vulnerabilities, any possibilities where a hacker can leak through. And therefore, this is, and you may do this every night. I know every night I go check the house. I check every door and every window to make sure the locks are secure so bad people cannot come into my house. We have the responsibility as health information managers to ensure that all of the locks and all of the doors, both literally and figuratively, are protected in our computers, because we cannot see these open windows or broken latches like we do in our house. So therefore, this has to be done with the cooperation of the IT department. And remember, the IT department is part of the Health Information Informatics department. All right, so there are three primary types of safeguards that the HIPAA security rule spells out. And the Department of Health and Human Services in the OCR has a very good summary of the security rule as well that I recommend you use as a study guide to give you the highlights. So, the administrative safeguards include that risk analysis, also acting upon what risks, what vulnerabilities were identified in the analysis. We must designate a security officer, just like we have to have a privacy officer under the privacy rule. And we also must make sure that our workforce is trained and monitored. And we also must make sure that the proper authentication is done and due diligence on every individual before we authorize access to electronic protected health information. And this goes into the safeguards and access controls, such as who can write into a patient's record, who can read the record, that is an access control, and that must be determined by the individual's job requirement after due diligence. Physical safeguards go to what we were discussing before about the locks on the doors. And this time it's literal, okay? The physical access to where the computers are must be limited to authorized personnel only. And the policies and procedures for any kind of transfer, removal, disposal. This also has to do with destruction of records of electronic media would be included here, such as no non-encrypted USB jump drives. And the technical safeguards, these have to do with the actual access controls. So the easiest one, the one that you're most familiar with, I'm sure, is username and password. But now we have to step up our controls. And in a lot of cases, we're using biometrics. You may have that on your cell phone where you use your fingerprint to get in instead of a username and password. That is all, biometrics is all part of access controls. Audit controls, integrity controls. Remember, if we do not make sure that we can authenticate that the physician of record is the one who entered this information, then we cannot trust the information. And if you cannot trust the information, how can you take care of the patient? And then, of course, transmission security has to do with encryption and the various types of encryption. Yes, you have to know all of this. Workforce security standard has to do with making sure that only those with legitimate need to access information are able to do so. But sometimes you are going to have, for example, a nurse who is authorized to access patient records. And you don't need to go to the point where they can only access those patient records who they are assigned to, because sometimes a nurse has to help with somebody else's patient. Or maybe they get switched all of a sudden because a nurse on another floor didn't show up. Or maybe this patient is discharged and another patient is placed into the care of this nurse before the IT department can be notified. So that means there has to be flexibility in that nurse's legitimate need to access. However, again, we are talking about training so that that nurse knows if that is not your patient, if you do not have legitimate need to access that information, we're going to know. And this has to do with alerts and reports of access. The addressable security rule has to do with the flexibility of compliance. And this is for the example I just shared with you about the nurse, is we have to remember that the patient does come first. That does not lessen our responsibility for keeping this information secure. However, there are going to be reasonable and necessary aspects. As we talked about, if you remember, with the parts of HIPAA's privacy rule that says there are certain situations where you cannot release or use or disclose, but then there are situations where you can use your best judgment. And this is all a part of the process with the security rule as well. However, the important thing is that we in health information management must have a way to know about what's going on and ensure that it is reasonable and still compliant. The release of information, ROI. Those of you who have studied business may know ROI stands for return on investment, and that is correct. However, in health information management, ROI stands for release of information. And there is a very specific process that one must go through in order to comply with the privacy rule and the security rule to make certain that all staff is compliant. Now, when requesting a patient's record, it's usually a lot smoother, and the situation also usually comes about when a relative of the patient is asking for a copy of the records, such as a spouse, a child, a parent. And this is where the release of information rules must be complied with. When there is a request for information, it is your responsibility to make sure that all of the staff that can be involved in release of information are very well trained in how to authenticate the requester. And yes, this is a point of contention. I am her sister. I have a right to know. Well, not necessarily. Or my wife asked me to come by. Well, you know, relationships like being a sister or being a husband cannot be easily authenticated. But there are very strict protocols for authentication. You are responsible for knowing them and making certain that you are not ever releasing patient information without the proper authentication and authority. PHI pertaining to behavioral mental health or substance abuse or the sexual activities of a teenager are all known as super confidential. HIV status, drug or substance abuse, mental health all have extra special controls with regard to who can access information and how to authenticate that the release would be proper. So make sure you review these factors as well. Okay, if you have any questions, please post them to the RHIA Exam Prep Discussion Forum or email your instructor.